The Constitution deliberately used words which cloaked their real intention, and it would have been so simple a matter to make the intention clear beyond any possibility of doubt. There is clear indication that the drafting committee was conscious of the need for having express provision regarding limitation on the power of amendment in case such limitation was desired. This is clear from Article 305 of the draft Constitution, which immediately followed Article 304, corresponding to Article 368 of the Constitution, as finally Klop T.C. the speech of Dr. A.M.B.C.D. Carr, made on September 17, 1949, while dealing with the provision relating to amendment of the Constitution, makes it clear that divided the various articles of the Constitution into three categories. There was nothing in his speech to show that apart from the three categories of articles, there was a fourth category of articles contained in Part 3 which was not amendable, and as such could not be the subject if amendment. The Constitution, First Amendment Act 1951, which abridged and amended certain fundamental rights contained in Article 19, was passed by the Provisional Parliament, which had also acted as the Constituent Assembly for the drafting of the Constitution. The First Amendment is a contemporaneous practical apposition of the power of amendment under Article 368. The contemporaneous practical exposition furnished considerable D in resolving the doubt in construing the provision of the Article 48 to 653, Queen v. Sal, Buren, 1878, 3 Appeal, Cam 889 and William McFerrin v. Robert R. Blaker, 146, U.S. referred to. This court has now accepted the view in its decision since Golak Notlil Ace that the speeches made in the Constituent Assembly can be ERRCD2. While dealing with the provisions of the Constitution, the speeches can be referred to for finding the history of the constitutional provision and the background against which the provisions were drafted. The speeches cannot form the basis for construing the provisions of the Constitution. I. Golak Nath Orsvi. State of Punjab, 1967 2 SCR, 762, H. Maharayadirai Mad. Havraufi Wairosh India Bahadur Orsvi, Union of India 1971 3 SCR 9, Union of India VHS. Dillon, 1972, 2 SCR 13 3, Kesavananda Bharati, Kesavananda J. 51. The amending clause is the most important part of a constitution upon its existence and truthfulness through T is its correspondence with real and natural conditions depend. The question as to whether the state shall develop with peaceable continuity or shall suffer alternations of stagnant ion, retrogression, and revolution. The framers of our Constitution were conscious of the desirability or ondling the urge for change with the need for continuity. They were not oblivious of the phenomenon writ large in human history that change without CCL continuity can be anarchy, change with continuity can progress, and continuity without change can mean no progress. The Constitution makers have, therefore, kept the balance between the danger of having an unamendable Constitution and a Constitution which is easily amendable. No generation has monopoly of wisdom, nor has any generation a right to place fetters on future rations to mold the machinery of government and the laws according to their requirements. The grant of power of amendment is based upon the assumption that as in other human affairs, so constitutions there are no absolutes and that the human mind can never reconcile itself to fetters in its quest for a better order of things. And it is not permissible under Article 368 to so amend the Constitution as to take away or abridge the fundamental rights in Part 3. The conclusion would follow that the only way to take away or abridge fundamental rights is to resort to extra-constitutional methods like revolution, between peaceful amendment, through means provided by the Constitution, and the extra-constitutional method with it. As dangerous potentialities, the former method is to be preferred. 663 to 670. The consequences which would follow from the acceptance of the view that there is no power under Article 368 to abridge or take away fundamental rights would be chaotic. It is one of the well-settled rules of construction that if the words of a statute are in themselves precise and unambiguous, no more is necessary than to expound those words in their natural and ordinary sense. The words themselves in such case best declaring the intention of the legislature. It is also well settled that where alternative constructions are equally open, that alternative is to be chosen, which will be consistent with the smooth working of the system which the statute purports to be regulating, and that alternative is to be rejected, which will introduce uncertainty, friction, or confusion into the working of the system. These principles of construction apply with greater force when dealing with provisions of a